Morning, everyone. Thank you for joining PHCA for today's webinar entitled Criminal Background Checks After the Peake Decision, What You Need to Know to Remain Compliant. My name is Abby Foster. I'm the Director of Marketing and Member Services at PHCA. PHCA offers monthly members-only webinar for NAB-approved credits, and we were happy to open this webinar up to both members and non-members. There are almost 500 individuals registered for today's topic. Thank you for joining us. Before we get started, I have a few housekeeping items to cover. The slide deck is available at the link on the right-hand pane, as well as in the reminder email that was sent this morning. If you have dialed in by phone, please select telephone and enter your audio PIN. The webinar will be recorded and made available on the PHCA website, public for members and non-members. The webinar has been approved for 2 NAB credits for nursing home administrators, and certificates will be emailed following the presentation. All attendees will be in listen-only mode. Please submit questions using the pane. We will use time at the end of the formal presentation to have our presenter answer questions. The objective of today's webinar is to analyze the hiring implications of the Peake decision that found the lifetime employment ban for certain crimes to be unconstitutional, interpret the Commonwealth Court's guidance regarding hiring discretion on a case-by-case basis, adapt hiring practices to ensure compliance with OAPSA and other state and federal laws. Our presenters are Paula Sanders and Andrea Kirschenbaum from the firm Post & Schnell. Thank you for joining us today and offering this educational webinar. Now I'm going to turn control over to our presenters. Once you are done, they will moderate the Q&A.
Thanks very much, Abby, and good morning, everyone. This is Paula Sanders speaking. I'm a principal and co-chair of Post & Schnell's healthcare practice. We work very closely with PHCA and also with Leading Age PA, and collectively felt the need to do a presentation trying to address some of the issues that you're all confronting in light of the Peake decision. I'm here today with my co-presenter and partner, Andrea Kirschenbaum. I'm going to just give her a second or two to introduce herself so you'll get used to recognizing if I'm talking or she's talking by the sounds of our voices.
Thank you, Paula, and good morning, everyone. Thank you for participating in this webinar. I'm Andrea Kirschenbaum, and I'm an employment law principal at Post & Schnell. I advise and counsel employers in the healthcare space, and I also litigate on their behalf the whole range of employment-related issues, and in my practice I've confronted many of the background check issues that we're going to discuss today.
So just sort of by way of background, let me tell you all, we feel your pain. When the Commonwealth Court found a provision of the Older Adult Protective Services Act unconstitutional, I think everyone was hoping that there would be either an appeal or clear guidance coming from the agencies who are responsible for OAPSA and who are regulating you. And as you all know, and we'll be talking about in a few more minutes, the Wolf administration decided not to file an appeal. So we are now stuck with a court ruling that has invalidated the lifetime ban of the Older Adult Protective Services Act. But we're also confronted with the fact that there are no bright lines anymore about what you're supposed to do with applying OAPSA, because the only thing that has been declared unconstitutional is the lifetime ban. So you really are stuck between a rock and a hard place. We're going to spend a lot of time talking about the specific provisions of the Older Adult Protective Services Act, but for those of you who are skilled nursing facilities, I wanted just to give you some federal background and suggest as well that you use some of this material, keep it on hand because it's going to give you some additional ammunition as you go through the process of trying to determine whether or not you're going to hire someone. For those of you who are personal care homes or home health or other regulated agencies that are not subject to the federal nursing home requirements, just bear with us for a few minutes, because these same concepts are going to apply. So if we start with the federal regulations for nursing homes, skilled nursing facilities, or SNFs, we recognize that there is a federal requirement that facilities keep residents free from verbal, sexual, physical, mental abuse, corporal punishment, and involuntary seclusion. And all nursing homes who are Medicare certified or Medicaid certified are required to develop and implement written policies and procedures that prohibit mistreatment, neglect, and abuse of residents and misappropriation of property. Additionally, facilities are prohibited from employing individuals who have been found guilty of abusing, neglecting, or mistreating residents by a court of law. You just pause right there and look at that language. The specific prohibition for hiring under federal law is whether or not someone has been found guilty of abuse, neglect, or mistreatment of residents. So that's your regulatory grouping right there. Or if they're a nurse aide, if they have a substantiated finding in the nurse aide registry concerning abuse, neglect, or mistreatment of residents or misappropriation. So that's one set of prohibited employment criteria under federal law. But federal law then goes further and says, okay, these are the people you can't hire, but if you have any knowledge of actions by a court of law against an employee, which would indicate unfitness for service as a nurse aide or other facility staff, you're required to report that either to the state nurse aide registry or licensing authority. Additionally, you have to provide evidence to the surveyors and maintain efforts to determine if people you have hired have records of abuse or neglect. And this comes right out of the Appendix Q of the State Operations Manual, the guidelines for determining immediate jeopardy. So we're looking at what are the surveyors going to be looking at? They're required to investigate whether you have evidence showing you have used reasonable diligence to determine if persons you've hired have records of abuse or neglect. The surveyors are also going to be screening to see whether you have screened employees for for a history of abuse, neglect, or mistreatment of residents. So not only are we've got this obligation on the federal requirements, but what I want to now do is walk through what are the surveyors being told to look at. So with respect to screening, when the surveyors come in, and this comes right out of the State Operations Manual Appendix PP, which is the regular guidance to surveyors, this is for FTAG 226, they're going to look at, as I mentioned before, to see whether or not you're screening. And that in Pennsylvania has not changed at all, because OAPSA still requires all of the background checks, either with the Pennsylvania State Police or the FBI, depending on how long someone has been living in Pennsylvania. But the federal regulations go further, at least in the State Operations Manual, and says that the surveyors are also going to be looking for whether you attempted to obtain information from previous employers and or current employers. So not only are we talking about the criminal background checks, but you still have to do your normal background checks of prior employers. Additionally, they expect you to be checking with the appropriate licensing boards and registries. That hasn't changed. These are still the normal employment policies that I am sure all of you have in place, regardless of whether you're a skilled facility, a hospice, home health, or personal care or assisted living residence. So what's the intent? The federal intent is that nursing homes must not hire a potential employee with a history of abuse if that information is known to the facility. As I mentioned before, you're required to report knowledge of actions by a court of law against an employee that indicates the employee is unfit for duty. This is coupled with your obligations to report alleged violations, conduct investigations of all alleged violations, report to the proper authorities, and take necessary corrective actions with respect to allegations of abuse, neglect, or misappropriation of property. The interpretive guidelines go on to say that the surveyors will be looking to see how thorough you are in your investigations of the past histories of individuals you're considering hiring. So that goes beyond what is in the regulations, and in the guidance suggests that the surveyors will be looking to see whether you've made reasonable efforts to uncover information about any past criminal prosecutions. Now remember, not every state requires criminal background checks. Pennsylvania is one of the many that do, but there are several that don't. That reasonable efforts to uncover information you're already doing and have been doing for years and years and years under the Older Adult Protective Services Act. So as long as you're maintaining evidence of obtaining those background checks, you should be meeting this requirement here. The guidelines go on to define what in the federal scheme found guilty by a court of law means. And that's where a defendant has pled guilty, is found guilty, or pleads nolo contendere. That's further than the Older Adult Protective Services Act, which only looks towards convictions. So you can, under federal law, take into account some of these other factors in determining suitability for employment. A finding, when it's used, refers to a determination by the state agency or the CNA registry that validates allegations of abuse, neglect, mistreatment of residents, or misappropriation of property. If a certified nurse assistant has been found guilty of neglect, abuse, or mistreatment of residents, or misappropriation of property by a court of law, that individual is required to have their name entered into the nurse aid registry. If you have a prospective employee who is on the nurse aid registry, by federal law, you may not employ them, right? You cannot employ someone who's on the registry. If the nurse aid wants to challenge the fact that they are on the registry, they can petition to have their name reviewed, and to have their case reviewed and their name removed. That's not something that you all have to worry about, okay? So the fact that we've got this nurse aid registry covers a whole host of our prospective employees. If you have a prospective employee who has an allegation or has a conviction, you may want to consider making a referral to the Department of Health for them to consider whether or not this individual should be added to the nurse aid registry, because once they're on that registry, that removes your discretion, okay? And most of the rest of what we're going to be talking about today really has a focus on how you as employers are going to be required to exercise reasonable diligence and discretion in determining whether or not you're going to hire somebody. A licensed staff member, if you have an LPN or a nurse, physician, or any other licensed professional who has been found guilty of neglect, abuse, or mistreatment of residents or misappropriation of property, they're required to be reported to their respective state licensing board. Interestingly, when we go forward, you can see that under FTAG 225, the State Operations Manual suggests that when you're trying to determine whether an individual is unsuited to work in a nursing home, let me just back up for a minute here, and that unsuitability under the guidelines includes a felony conviction of child abuse, sexual assault, or assault with a deadly weapon. You must report that individual to the nurse registry if a nurse aide, or the state licensing authorities if a licensed staff member. But the neat thing is, and we'll start talking about how are you using your discretion, for those of you who are skilled facilities, you can go back and use this as a nexus. We can point to this as evidence. It says, listen, the Centers for Medicare and Medicaid Services have told us as certified facilities that felony convictions for child abuse, sexual assault, or assault with a deadly weapon is indicative that an individual is unsuited to work in a nursing home. The guidelines then go on to say not only are we looking at mistreatment, neglect, and abuse of residents and misappropriation of resident property, but when you're considering actions by a court of law, even though the regulations on its face suggest we're only talking about actions involving residents, the interpretive guidelines go one step further and say the nursing facility should consider treatment of other individuals outside the facility which you determine to be such that the individual should not work in a nursing home environment. So we're going to talk in a few minutes about what we're going to call the Peake factors. What I want you to keep in mind are these initial slides can be used as evidence if you do decide to not hire someone, that you can pull out these federal guidelines and say, listen, we've looked at this. This is from the folks who certify our participation in the Medicare and Medicaid programs. These are also the guidelines that the Department of Health uses for licensure purposes because Pennsylvania Department of Health regulations incorporate the 483.13 regulations. So, both from a licensure perspective and a Medicare and Medicaid certification perspective, we have support for declining employment if we believe someone is a potential risk to our residents as due to a criminal conviction. I also want to now spend a few minutes talking about the Department of Health nursing home regulations to give you further support. You're all aware that the department, at least with regard to nursing long-term care facilities, requires the governing bodies to adopt rules concerning health and safety of residents and the protection of personal and property rights. Your personnel records, and this is important, and for those of you who are licensed by the Department of Human Services, very similar regulations in place. So whether we're talking about nursing homes or assisted living residences, personal care homes, or other healthcare facilities licensed by the Department of Health, all of you are required to keep personnel records that are current and available and that support information as to why you hired that person. And that's going to include not just your criminal background checks, but, you know, did you check references? Is the person appropriately licensed? So if you haven't taken the time recently to go back through your personnel policies, use this as an opportunity to do so. And we're going to suggest, and Andrea is going to give you a lot of great suggestions about some of the things that you may want to include in your policies if they're not there already. Don't forget that to the extent that you hire or use outside resources, even though you've outsourced that responsibility or that job position, ultimately as the employer, as the licensed entity, you're still responsible for making sure that people being provided to you to provide services to your residents are appropriately screened. So two other points before we get into the meat of OAPSA. The Office of Inspector General in October of 2012 released a report where they analyzed criminal convictions for nurse aides and then compared those criminal convictions to various nurse aide registries to see whether there was any correlation between CNAs who had criminal convictions and CNAs who had substantiated findings on the nurse aide registries. And I included this information or material so that if you do make a Peake decision not to hire someone, this will give you some additional support for making that decision. This Office of Inspector General report found that 19% of aides who were found guilty of on-the-job abuse, neglect, or property theft in 2010 had prior criminal convictions. So that's almost 20% of nurse aides who were on the registry for having abused or neglected or some sort of property theft. About 20% of them, or one-fifth, had prior criminal convictions. And what was really interesting to me when I looked at this is that 53% of those prior convictions were for crimes against property, burglary, shoplifting, and writing bad checks. So, you know, when we started preparing to do the webinar, I was thinking, well, you know, maybe some of these property crimes aren't that severe. But when you look at this OIG finding that you've got 20% of the nurse aides with substantiated findings and 53% of them had convictions for property crimes, right? So there's really three types of crime. We have property crimes like this. We have crimes against the person, which is like sexual assault and violent crimes, and then you have the drug crimes. So if you put three buckets, 53% of the CNAs on these registries had convictions for property theft. So, you know, to the extent you need some sort of validation, if you decide you're not going to hire someone who had a property theft conviction, you may want to go back to this OIG report as support for that determination. CNAs with substantiated findings of either abuse or neglect were 3.2 times more likely to have a conviction of crime against a person. than nurse aides with substantiated findings of misappropriation. So, I mean, it seems to me that the OIG was finding correlations that were fairly substantial. And Andrea, I just wonder if you have any thoughts on that from a...
Thanks, Paula. So I think that, you know, we'll get more into this later. The question is really a nexus question, but if you can, in the job description, identify that there's going to be significant access to property, then there's a nexus if you decide not to hire someone on the basis of a prior property crime. Obviously, these statistics in terms of convictions of crimes against persons is very significant and startling, and a useful piece of data as you all think about this process going forward and trying to substantiate your decisions and then document them later.
The 2010 OIG findings were also significant to me, and I've included this table for your reference because it shows what I call the recidivism rate. You can see that even people who may have had a finding or a criminal conviction that was 30 years old still wound up on the substantiated findings list. So while Peake has outlawed a lifetime ban, you all are stuck with that burden now of using reasonable diligence to determine whether or not you're going to hire someone. The final point I want to make on OIG findings is in 2015, just last May, in fact, almost a year ago, the OIG was required by the Affordable Care Act to conduct a review of home health agency employees to see what kind of background checks home health agencies were doing and what they found. And it was interesting to me because the report identified a Pennsylvania home health agency who had employed a certified nurse assistant in March 2013, and the CNA had 2 convictions for assault and 2 convictions for possessing an instrument of crime in February 2010, and they were hired. And the OIG concluded that it was okay for that home health agency to have hired the aide because the OIG mistakenly believed that in Pennsylvania neither assault nor possessing an instrument of crime were among the offenses that would disqualify an individual from home health agency employment. And that highlights one of the problems about being licensed in Pennsylvania. And I say this with all due respect to our friends in who regulate us, but we're not a very coordinated state. So we have the Older Adult Protective Services Act, which is under the jurisdiction of the Department of Aging, but the Department of Health licenses all sorts of health care facilities and sometimes requires criminal background checks, but other times can say, okay, the Older Adult Protective Services Act already requires you to do criminal background checks, so we don't have within the licensure regulations a cross-reference back to the laws that we're otherwise required to comply with. So I just want to share that with you, and now let's move forward and really get into the meat of the Older Adult Protective Services Act, the Peake decision. And the key things to keep in mind as we go through all of this is you have to take seriously what you see in the results of these criminal background checks. The Peake decision, the Commonwealth Court law, did not remove the requirement to do background checks. We received several questions before the webinar asking, do we still have to get background checks? And the answer is yes. The Older Adult Protective Services Act exists. All of the requirements that you've been used to complying with are there. There's very limited changes, so everything else you're used to remains. The question now is, what do you do if you get a positive hit on a background check? And our advice to you is take seriously what you see, act accordingly, make a reasonable decision, and document in accordance with applicable laws. So we wanted to give that as a brief background to allow people who were logging in late to the webinar to catch up with us. Now we're going to spend the rest of our time together talking about Peake and the numerous other employment laws that you're going to be confronted with. The Older Adult Protective Services Act was first enacted in 1987. It was amended in December of 1996. It was amended again in June of 1997. In 2001, there was a Commonwealth Court case in which certain provisions of OAPSA, the Older Adult Protective Services Act, were challenged. And the court held in what we call Nixon 1 that the provisions of OAPSA as applied specifically to the plaintiffs, to the people who challenged the law, that the law was unconstitutional as applied to those particular plaintiffs. But Commonwealth Court did not invalidate the Older Adult Protective Services Act or any provisions of it as applied to anyone who was not suing the Commonwealth in the Nixon 1 suit. Nixon 2 was decided by the Pennsylvania Supreme Court in 2003, and it upheld the Commonwealth Court decision, again, finding only that the law was unconstitutional as it applied to that specific group of people who brought the challenge. In response to Nixon 1 and Nixon 2, the Department of Aging issued an interim policy, and that's the policy everyone has been operating under until January of 2016. That policy is gone. The Commonwealth Court decided in its ruling in the Peake case in December 2015 that the Department of Aging's interim policy was invalid. It was not legally binding because it was an interim policy. It was not even a statement of policy. So the Department of Aging's interim policy is gone, and we're left with Peake, the Commonwealth Court decision of December 2015. And all that decision did is say lifetime bans are unconstitutional. That is the only change that we are looking at. OAPSA covered facilities, and this will tell you whether OAPSA applies to you or not. Under the statute, you are covered if you are a dom care, home health care agency, long-term care nursing facility, older adult daily living center, or a personal care home. If you're licensed by the Department of Human Services, formerly the Department of Public Welfare, they have included under their regulations the following facilities who are also now covered by OAPSA: assisted living residences, community residential rehabilitation services, community homes for individuals with intellectual disabilities, family living homes, ICF IIDs, residential treatment facilities for adults, state mental hospitals, long-term structured residences, and sexual responsibility treatment programs. If you're licensed by the Department of Health, and you're not on these previously two slides, but you are a hospice, birth center, home care agency, home care registry, or a hospital with a skilled nursing facility or an extended care unit, you are also covered by OAPSA. If you are not in one of these regulated groups, you may want to get off the phone and find a better way to spend the next hour and a half. But these are the ones who are covered by what OAPSA requires. Who must be screened? Applicants or employees, and that's defined as an individual who would be employed by the facility. It includes contract employees who have direct contact with residents or unsupervised access to their personal living quarters. It includes any person who enters into a contractual relationship to provide care to a care-dependent individual for monetary consideration in their place of residence. Who does it not include? Volunteers. You're not required to get an OAPSA screening for volunteers. Otherwise, if you're concerned, do I need to screen this person, go back to this slide, and that is the definition. Here on these next two slides are the list of the OAPSA prohibitive offenses. This list has not changed. These are still the prohibitive offenses. The only thing that has changed is the fact that someone has been convicted is no longer a lifetime ban on employment. So if you get a criminal background check and somebody has a positive hit on one of these prohibitive offenses, you're going to have to go through what we're going to be talking about, which is this reasonable due diligence to determine whether or not you can employ the individual. Actually, 3 slides worth of these OAPSA prohibitive offenses. 30 to 90-day provisional employment requirements, that didn't go away. If someone lives in Pennsylvania, you can hire them and you've got a 30-day provisional time period. If they've been out of state, you have the 90-day provisional employment requirements. And those requirements are still the same, right? They have to provide proof that they applied for the background check. They have to swear or affirm in writing that they've not been convicted of any of the offenses contained in the Act. You, as the administrator, have to have no knowledge or information pertaining to the applicant which would disqualify them from employment under OAPSA. The provisionally employed applicant still has to receive an orientation which provides information on policies, procedures, and laws which address standards of proper care and recognition and reporting of abuse or neglect or both of recipients. And if you're employing somebody provisionally, they have to receive regular supervision. And the results of that supervision should be documented and contained in the personnel file. So when either the Department of Health or an inspector from the Department of Human Services comes in and you've got someone that you've provisionally hired, you're going to need to still show evidence, just like you did before, that you were supervising them appropriately during their provisional hiring period. So now let's talk about Peake. Those of you who've heard me speak before know I'm fond of saying bad facts make bad law. These are the Peake plaintiffs. The first one was a 52-year-old. They were riding in a stolen car when they were 18. They served 3 years probation, and they had a permanent lifetime ban on employment under OAPSA. Plaintiff number 2 was a 60-year-old LPN. When they were 43, they were arrested, possession of drug with intent to deliver. They did jail and drug rehab program, but could not be employed by a health care facility covered by the Older Adult Protective Services Act. Plaintiff number 3 was 55 years old. They were a cook. When they were 20 years old, so that's about 35 years before the lawsuit, they were convicted of robbery, attempted theft by unlawful taking, aggravated and simple assault related to a fight at a neighborhood basketball court. So, somebody would look at that and say, well, that was a young offender, 20 years old, lifetime ban. They were also convicted of disorderly conduct at the age of 22. When you read through everything, you'll see that this particular individual had some issues with substance abuse, but they've been sober for 24 years, but could not get a job in a healthcare facility as a cook. The fourth plaintiff was 48 years old. They had experience doing maintenance, cleaning, and food service. They borrowed a car from a friend, didn't realize the car was stolen. They were so afraid that they were going to lose their job that they pled to theft by receiving stolen property when they were 33 years old and served 2 years probation. And I think this case points to one of the problems that we see in some of these cases, especially with prospective employees who may be from a lower socioeconomic class, who think that, okay, it's better just to quickly plead to a lesser crime, so I'm not going to get in a lot of trouble. This person pled, served 2 years probation, but that conviction still stayed. Final person was age 39. They did elder and child care for friends. They were convicted of writing bad checks when they were 23. And at age 24, borrowed a car from their cousin, not knowing that the car was stolen. So, I mean, the curious thing to me, aside from the criminal convictions, is the likelihood of finding so many people to join as plaintiffs who have friends who steal cars and not know it. But putting that piece aside, the court was really moved by these young offenses and thought that the life ban, without any ability to consider employment, was unconstitutional in light of the Pennsylvania Constitution. Also, you should know that there was a human services organization who joined the Peake plaintiffs. And we see this a lot. I don't know if there are any people on the phone who do substance abuse counseling, but a lot of substance abuse providers have found that reformed addicts are sometimes the best counselors, and some of these drug offenses would preclude employment. So what did Peake change? Only that lifetime ban. Also, before Peake, when the Department of Aging received an FBI background check for a provisionally hired employee, they would let you know as the employer that this person had a positive hit on the background check. If it was a conviction for a prohibitive offense, you were told, and you knew you could not hire them. You had to get rid of them. Department of Aging is no longer giving you that information, right? They're not saying to you, okay, Paula, you cannot employ Andrea because she's had a prohibitive offense. Instead, what they're doing is giving the criminal background check result directly to the applicant. Then the applicant has to come to you and say, okay, prospective employer, here is my criminal background check. What are you going to do about it? And the response is you're going to have to exercise judgment and comply with a number of other employment laws that Andrea is going to talk about in a few minutes. So when the court came out with its decision, it's identified what we're calling the Peake factors. If someone receives a criminal background check and they have a prohibitive offense that is older than the time frames already provided for in Peake, in the Older Adult Protective Services Act, you're going to have to look at the nature of the crime, the facts surrounding the conviction, the time elapsed since the conviction, evidence of the individual's rehabilitation, and the nature and requirements of the job. So keep this slide handy because this is going to become your policy, right? We know that the Department of Health surveyors are going to be coming in looking to see, do you have background checks? I believe they are also going to be looking for whether or not you have a policy on how you're interpreting background checks. Same thing I think is going to hold for those of you who are going to be inspected by the Department of Human Services, and if you're an adult day, if you're being inspected by the Department of Aging. Your policies should say, if we have a positive background, criminal background history, we are going to review the nature of the crime, the facts surrounding the conviction, time elapsed since the conviction, evidence of the individual's rehabilitation, and the nature and requirements of the job. Unfortunately, nobody in the Commonwealth is putting out a statement that tells you to do this, right? So the Department of Aging has put on their website that criminal background checks are still required, and this is a direct quote from their current website. The department recommends that facilities subject to OAPSA requirements consult with an attorney prior to making an employment decision to ensure compliance with the Commonwealth Court's guidance regarding exercising discretion on a case-by-case basis. That was current as of this morning. So you've got to do this case-by-case analysis. You can't have a policy that says, we will never hire a serial rapist. In reality, you're probably never going to hire a serial rapist, but your policy cannot say that because you still have to go through this case-by-case analysis. Just the same way, you know, many of you have policies that talk about we're not going to admit a patient or a resident who's a sex offender. Well, in reality, your policy probably says we will analyze whether we can meet the needs of a convicted sex offender while protecting the health and safety of our residents and staff. So you're doing a case-by-case analysis, but we would suggest you not adopt a policy that just makes a blanket statement of we will never hire a person convicted of X, because that policy in and of itself could be challenged under the Peake case.
Okay. Thanks very much, Paula. So I'm going to speak about, just turning the page a little bit, about the various different other federal, state, and local requirements that you all are confronted with in terms of how to conduct criminal background checks, what process to use, what factors to consider, and, you know, we're at various different levels at this point. I think, you know, everyone's really focused on this Peake decision because although there was a lot of chatter after the Nixon decision, the Nixon was only with respect to those Nixon plaintiffs. You know, the Peake decision is far broader because it was a facial challenge to the statute, so obviously it applied not only to those folks that were listed, Paul was discussing about Peake, it applies, you know, on a going forward basis, and that portion of the statute is gone. I think just to take a quick step back, I think that, what we're seeing now with the various different requirements is part and parcel of a larger social movement to provide offenders with an opportunity to turn their life around. And I think that's a lot what we're seeing in this national Ban the Box movement. And I'll speak a little bit about the Philadelphia Ban the Box. But I think that it's just important to think about it that way, and I think that obviously there was some care taken in selecting those Peake plaintiffs because, obviously there's a strong social movement going on in the background that's animating a lot of what's going on both on the litigation front and with regard to the various different requirements. So the first thing that we're going to speak about briefly is the Fair Credit Reporting Act. And when you see the title, you think credit report. You think, getting your FICO credit score. And so while it certainly applies to that, you wouldn't on the face of the name of the statute think, okay, well, the Fair Credit Reporting Act applies when your facility gets a background report regarding criminal information. So the statute applies to criminal background reports obtained by third-party consumer reporting agencies and then transmitted to you all. So if you were to use like a TransUnion or an Equifax or any kind of third-party agency to get your criminal background reports, that's when the Fair Credit Reporting Act comes into play. The Federal Trade Commission, or the FTC, is the federal regulatory body that's responsible to enforce the Fair Credit Reporting Act, which I'm just going to call FCRA, which is what we call it. And what the first requirement of FCRA that I just wanted to mention, and there really are three key aspects of FCRA I'm going to speak about. The first is the consent form. You all need to obtain written consent prior to obtaining a criminal background report to the extent that you are needing to comply with FCRA. And again, FCRA is only going to come into play if you're getting reports from a third-party consumer reporting agency. It seems sort of on its face very easy. Okay, well, I'm just going to do a one-paragraph, requirement to obtain written consent. And the one thing I would say about FCRA, and more so than anything else I'm going to be speaking about, FCRA is very specific and has very specific requirements. And so just as one example, the consent form needs to be a standalone form. It can't be along with other pre-employment paperwork. And there's been some litigation on that front and pretty big settlements in the millions of dollars for cases where that form was not standalone and was just, along with some other pre-employment documentation. I just included in the slides, and I'm not going to read it to you, but what the definition of consumer reporting agency is, just so you all can think about where are you getting your background checks that include criminal history information from, so you can better assess whether you're getting it from a consumer reporting agency and you need to be complying with FCRA. So the first thing that we talked about was obtaining that written consent. The second thing is what is called in FCRA lingo a pre-adverse action notice. So you have in your hand the results of the criminal background report, and you think that that precludes the person from getting the job. You need to, before you make that decision, provide this pre-adverse action notice and give a copy of the report, provide a summary of rights, and again, there's very specific language that's required, and the real purpose behind this is to give the applicant or the employee an opportunity to raise their hand and say, look, that's not me, that's a different, John Jones, and here's the proof, so that a mistake is not made. So that's what the purpose is, animating the pre-adverse action notice, so that an employment decision or another decision, because this is beyond employment, it applies in other contexts, getting a bank loan and things like that that we're not going to talk about. But it gives the opportunity for the applicant or the employee in your context to say, look, that's wrong. And then ultimately, After the pre-adverse action notice comes back, if you decide not to offer the job to the person or not to retain them, not to promote them, whatever the action is that's adverse to the person, there needs to be a notification, and it's best to notify in writing. And I just have listed on the slide what the information is that FCRA specifically requires in the notice. And it's, again, very specific language that's required in order to comply with the Fair Credit Reporting Act. I list very briefly what the remedies are. Generally, what we're seeing is, while there is some government enforcement activity, for the most part, this is a statute that's being policed by the private plaintiff's bar. And you'll see that for negligent noncompliance, it's actual damages. But if it's willful noncompliance, there can be, statutory damages per violation, as well as punitive damages. And, of course, attorney's fees and costs are available. There really has been an increase in Fair Credit Reporting Act litigation and class actions, and I'm sure you all could see how that could happen given the very specific requirements. If you're using the same form for everyone, it's a common practice, so it's something that a court might find could be litigated on a class action basis. And again, as you're just, I'm just, skimming the surface here, but you're getting the sense that there are just a lot of technical requirements under the Fair Credit Reporting Act. And I think that sometimes if employers are using a third-party service, their thought is that they're outsourcing responsibility in some way for this process. And while they may be outsourcing obtaining the background checks to a third-party source, the employer still, as and this is a common theme, and Paula covered this, the employer is still ultimately responsible for the forms that are going out. And so if the vendor is providing you with forms, if they're not complying with the Fair Credit Reporting Act, ultimately you all are going to be held responsible for those forms. And again, just as one example, this $6.8 million recent settlement from public supermarkets in Tennessee, the plaintiffs claimed that the notice requesting authorization to obtain the background checks violated the Fair Credit Reporting Act, and specifically that there was not a standalone form, so that the applicants were not really fully appreciating that they were authorizing that information. And again, that's a technical requirement under the Fair Credit Reporting Act. So that's sort of the thumbnail sketch of the Fair Credit Reporting Act, something for you all to think about. Not only how you consider the information, but how are you collecting the information, and are you collecting the information in a way that is not opening you up to some potential risks for violations of the Fair Credit Reporting Act. So we're going to switch gears a little bit, and we're talking both about Title VII and the Pennsylvania Human Relations Act, and they're really interpreted coextensively, which is why I'm covering them together, although mostly what I'm going to be talking about is Title VII. Obviously, you all are very familiar, and that Title VII prohibits discrimination on the basis of various categories, including race and national origin. And you might, think, well, what does that have to do with criminal background checks? And really, the focus of what I'm going to be speaking about is an EEOC guidance that was originally issued a long time ago and was recently reissued on consideration of arrest and conviction records. When we speak about Title VII and the PHRA, we're really speaking about two different concepts. We're speaking about disparate treatment and disparate impact. Obviously, we're going to speak mostly about disparate impact right now. In terms of disparate treatment, you can't have practices that require background checks of employees within certain protected categories and not others. But really, in terms of the disparate impact, the EEOC has taken the position that criminal record exclusions have a disparate impact. So impact certain races and ethnicities more so than others because of the conviction rate in those communities, and therefore to take a blanket approach and make decisions to prohibit employment of certain individuals because of specified criminal convictions has a disparate impact, and the EEOC would take the position that would be a violation of Title VII. I know most of what we've spoken about has been convictions, but I just wanted, since it's covered in the guidance, briefly to speak about arrests. And the EEOC has taken the position that just the fact of an arrest doesn't establish that criminal conduct occurred, but that doesn't mean that you have to put your head in the sand if a background check comes back and you see that someone's been arrested for something. The arrest can trigger you to ask questions as to what happened. You can't rely on the arrest itself, but you can, determine after inquiry, and after you do an initial inquiry, you can assess whether a further inquiry is justified, whether the underlying conduct questions their judgment or, the various different factors that relate to the suitability for employment. And the test, and it's a little different than the Peake factors that we discussed, but obviously you're seeing a common theme here. The test is whether the employer can demonstrate that the challenged practice, so the practice to make certain decisions based on certain criminal convictions, is job-related for the position in question and consistent with business necessity. So that incorporates an analysis of the position in question. So this is, again, the theme, case-by-case analysis. And the EEOC guidance further says that the employer must show that its policy operates to effectively link, so to create a nexus between the specific criminal conduct and its dangers and the risks inherent in the duties of the particular position. So the test, again, is a little different than the Peake factors, but the three-part test that the EEOC has advanced, and this is based on a prior case many years ago, the nature and the gravity of the offense or conduct, the time that has passed since the offense, conduct, and or completion of the sentence, and the nature of the job held or sought. I list very briefly what the remedies are under Title VII so that you have a sense of what you may be facing to the extent that your practices are challenged under Title VII. And I just list very briefly 2 class action lawsuits. One was a settlement in a case brought where there was a specific exclusion. So there was a blanket policy saying that an employer wasn't going to consider applicants with criminal history. There also was recent litigation brought actually in the Pennsylvania Human Relations Commission. It was a class action complaint brought by an African-American applicant. He was denied a job because of his criminal record. He had been convicted of killing a man 3 decades earlier. It was an involuntary manslaughter conviction, and the complaint says that he killed this person in protecting his family. And he sought a job at Integrity Staffing Solutions at an Amazon facility. And that matter was resolved in a private way, so we don't know what the nature of the resolution was and if there was or was not any monetary payment. So I wanted to take a couple minutes and speak very briefly about best practices, what we're recommending. And again, as Paul was saying, the end result may be similar in terms of the analysis that you're doing, but in terms of developing a policy, the policy should not include any categorical exclusions. And since there needs to be a nexus between the criminal conviction and the nature of the job duties, I know that, in the day-to-day managing all of the things that we manage, sometimes, those job descriptions gather a fair amount of dust. But I think that job descriptions really are our friends, and they merit a dust-off and a refresh, so that if the job description includes specific aspects of the job related to interaction with residents, relating to access to resident property, you all, I'm sure, get a sense of what I'm speaking about. But I think that, the job description will be very helpful to show a nexus if the criminal conviction relates to the job duties, or could suggest that the person wouldn't be able to perform the job duties. So I think it's worth looking at those job descriptions, assessing if they're current, and adding some language as appropriate.
So, Andrea, on that point, a lot of folks, I think, on the phone are really concerned about convictions that might indicate someone has a volatile temper, for instance, disorderly conduct, or some sort of assault. If we're looking at a job description that involves one-on-one interplay with residents, is there a way that could be included without showing some sort of disparate impact? Could you say something as benign as even-tempered?
Yeah, I mean, I would consider, if someone truly is going to be in a situation with one-to-one interaction with residents, to consider saying maintain composure during stressful, or you would have to think about some language. But if someone is going to be in a situation with residents where you're concerned about volatility, I think it's certainly an appropriate thing to include I don't want to call it a temperament requirement, but something along those lines. It certainly makes sense to consider that. So, and as Paula said, we're really talking about individual assessments based on both the job requirements and the criminal history. What is the connection? And so I think that this is a multi-step process. I think the last few months you all have been digesting the Peake decision, and now we have this decision not to appeal. So I think step number one is to develop a practice and a policy. And those are different. Of course, the policy is going to recite the Peake factors, as Paula was saying, but then the practice is, okay, well, I now have someone with X conviction. Now how do I go about analyzing what to do and what not to do? And so developing that practice, there's no one-size-fits-all answer, and you're not going to be able to sort of come up in your mind. And I don't think that it would really be necessarily beneficial to develop a comprehensive policy with offenses listed, because I really do think it needs to be an individualized analysis, and every situation is, a little different. Although, again, as Paula was saying, that's not to say that, you should be employing, a serial rapist to work with your nursing home residents. That's not, what we're saying at all. But just that, you look at the crime, you look at the job, and then you make an assessment, and then you document your findings that you believe that it would be unsafe or very risky to hire someone given their proximity to residents. And the documentation doesn't need to be significant. You write an email to someone, the hiring manager writes an email to human resources, you put it in, the file, you maintain it, and you go from there. So I think number one is developing that policy, number two, putting in place that practice, and then number three is training your managers, training your human resources professionals as to implementation of the policy.
And I think Andrea makes a terrific point, because what Peake gives you now is what you didn't have before, And that's the ability to use some discretion if there's somebody you want to hire. And an example that comes to mind is, let's say you have an applicant who was convicted of child endangerment, and it turned out that she was convicted of DUI, and she had her child in the back seat. And the conviction could be for child endangerment, but that would have nothing, perhaps, depending on what position you were looking at. I certainly wouldn't want her, driving my van in the daycare. But if she was going to be a cook, you'd like that ability to say, okay, it's a criminal conviction for child endangerment, but that's not a risk for what I'm looking at. The other point, when we go back to looking at these policies and the individual assessment, I think when the Department of Health or the Department of Human Services or Department of Aging surveyors or investigators come to look at what you're doing, they're going to want to see, did you use reasonable judgment? I really don't think they're going to hold you to a strict liability. So if you do go through this analysis and you say, okay, I'm going to hire somebody because I think they've met all of those Peake factors and they're safe, and it turns out that there's a subsequent event, if you have and can document that you've gone through these kind of steps that Andrea has just gone through with you, you should be okay. With respect to the hiring decision, it may not protect you from other sorts of deficiencies, but if you can't demonstrate that you went through this process and you hired someone, you're liable to get a regulatory citation for not having gone through this type of analysis.
Thank you, Paula. So the other important point to mention is that certainly Title VII does not preempt federal statutes and regulations that otherwise govern eligibility. So obviously Paula was speaking earlier about CMS regulatory requirements. Title VII doesn't preempt that in any way. Title VII also, and this is important when we talk about OAPSA, makes clear that state and local laws are preempted by Title VII if they require or permit the doing of any act which would be an unlawful employment practice under Title VII. So I think that, potentially the lifetime ban under OAPSA, it doesn't matter anymore, but academically, potentially, it could have been preempted, but we're past that point. But that's an interesting, thing to think about. Obviously, it's federalism, right? So federal law is going to be preempting any state law. So, if an employer's exclusionary policy or practice is not job-related and consistent with business necessity, the fact that it was adopted to comply with OAPSA doesn't shield an employer from Title VII liability. So. This gets back to the rock in the hard place or the devil in the deep blue sea analogy that Paula made at the beginning. So it's lots of competing regulatory requirements all facing you. So we're going to head into other Pennsylvania law. I'm not sure if you all are familiar with Pennsylvania's Criminal History Record Information Act, or as we call it, CHIRIA. The Act does not prohibit considering criminal convictions. It's really a notification statute. So employers can consider felony and misdemeanor convictions, but only to the extent to which they relate to the applicant's suitability for employment in the position for which he has applied. So, and this statute obviously predates the Peake decision. So, as long as you're conducting your individual inquiry and analysis based on suitability for the particular position, you're also at the same time complying with your obligations under the Criminal History Record Information Act. The other aspect, and it's sort of not unlike FCRA, is there's a notification obligation under TIRIA. So if there's a, in FCRA language, there's a decision to make an adverse action, employers in Pennsylvania have to notify the applicant of the decision and also have to make sure to include in that notification that the decision to hire was based either in whole or in part on the criminal history record information. And I've listed, again, the remedies that are available under this statute. There can be an injunctive action brought by the Attorney General of the Commonwealth, and there also is the ability for individuals to assert a private right of action for damages. Again, there can be actual damages, but punitive damages are capped at not more than $10,000. So generally, the remedy that's most significantly available is if you decide not to hire someone and they can't find a job for a while, it would be the out-of-pocket wage loss is usually how these cases become significant, as well as obviously the litigation costs and the attorney's fees. So we wanted to just report that there's been a recent case that was filed by a job applicant against a PA SNF pending in the Court of Common Pleas in Chester County currently, and it alleges a violation of the Criminal History Record Information Act. The applicant had applied for the position of a senior IT auditor position. The complaint alleges multiple violations, and the case is still in its infancy. It's in discovery. The convictions were a 1998 misdemeanor overpayment of welfare benefits, misdemeanor harassment, and an arrest for endangerment, and both the arrest and the conviction were considered. The applicant was given a conditional offer of employment. The convictions were disclosed. So sometimes in these situations, if someone doesn't disclose the conviction and then they certify on their application that they've been truthful and given you all the information, then sometimes employers rely on the dishonesty and not necessarily the underlying conviction in deciding not to hire. Obviously, then, if someone were to bring an action, the employer would have to show that that was the basis. So documentation, again, is really important. But the applicant was told that the convictions would interfere with the hiring. Relying on that information, the applicant resigned from her prior position, and then the conditional offer of employment was rescinded. The employer filed for preliminary objections, which is, the Pennsylvania motion to dismiss, and the court recently overruled those preliminary objections, and the case is now ongoing. I wanted to briefly cover Philadelphia's Ban the Box ordinance. There are various different Ban the Box ordinances throughout the Commonwealth, but Philadelphia's is the only one, to my knowledge, that applies to private employers that aren't either government contractors, or in some jurisdictions it applies to government entities. I know you all probably are familiar with the Ban the Box ordinance. It became law in 2012, but it was very recently amended with an effective date of just last month. And just, not to confuse everyone, I'm just going to speak about the current state of the law because there have been some very significant changes. So for Philadelphia employers, if you're, thinking about Ban the Box and you haven't taken a fresh look at this, it merits a fresh look because of the significant changes. The law applies to all employers, irrespective of the size. There are some limited exceptions, which we're not going to cover here. And it prohibits any inquiry into criminal background until after extending a conditional offer of employment, and that's a significant change. It does not apply if the inquiries or adverse actions prohibited by the ordinance are specifically authorized or mandated by any other applicable law or regulation. So if there's a specific requirement from the CMS regulations or otherwise, then Ban the Box is not going to stop you from doing what you're otherwise required to do under federal and state law. The other important piece is that the employment application cannot include a question regarding criminal backgrounds, and so If you operate both in Philadelphia and elsewhere, you need to have a separate application for Philadelphia, because the law specifically says that even if the question is on there and it says, please do not answer if you are in Philadelphia County, that still doesn't comply with the law. So you all should look at your employment applications. The ordinance has some features of FCRA, some features of what the EEOC is telling us, and then some additional more significant requirements. So it's a hybrid. After the conditional offer, employers can only consider criminal convictions within 7 years of the date of application, and that does not include any times of incarceration. It prohibits an inquiry into arrests and criminal accusations that didn't lead to a conviction, so you can't even ask. And again, that's, only if you're not otherwise required to do so by other federal or state law. And it specifically prohibits a blanket exclusion of applicants with criminal convictions. The factors, again, a little different than the EEOC's factors, a little different than the Peake factors. But obviously you're seeing a common theme at this point. The nature of the offense, the time that's passed since the offense, the applicant's employment history before and after the offense, the duties of the job, any character or employment references provided by the applicant, and any evidence of the applicant's rehabilitation since conviction. There also are notice obligations. If the applicant is rejected in whole or part because of a criminal record, the employer has to notify the applicant in writing. So again, similar to the Criminal History Record Information Act, the employer has to provide the applicant with a copy of the criminal history report. That's similar to FCRA. This is a specific requirement. The applicant has to have 10 business days to provide evidence of the inaccuracy of the information or provide an explanation. That's sort of FCRA-like, but it's very specific because it has that 10 business day requirement. And Philadelphia-based employers make sure to post that notice. The posting is available on the Philadelphia Human Relations Commission's website, so you should post that notice in your workplace. The remedies, again, you can file a charge with the Philadelphia Commission, and there are some remedies within the commission process, but then if the person sues, they can obtain certain relief like compensatory and punitive damages and court costs if the case goes to court. So that is Philadelphia's Ban the Box. I think, the key takeaways regarding the employment piece of the criminal background information is that the best ways for you to think about mitigating against the litigation risk is to develop FCRA compliant forms, to develop, again, policies and protocols that provide for that individualized assessment of the conviction in relation to the particular job. Is there a nexus between that job and that conviction? And document the basis for any adverse action taken. Obviously, be careful of email. Email is forever in many instances. While I think it's important to document, you have a conversation with your folks, and then you send a documenting email. But if you have concerns or you want to discuss some things, just think before you send your email, because obviously those emails could be Exhibit A in any litigation by someone challenging the consideration of their criminal background information under any of these statutes that we're speaking about. If you decide, based on your review, that you need to be not employing the person, you need to be given pre-adverse action notice under FCRA to the extent you have to comply with FCRA, an adverse action notice, even if you don't have to comply with FCRA, Pennsylvania employers still need to comply with the Criminal History Record Information Act, so they have to provide notice. And Philadelphia employers need to look at that additional layer of especially looking at your application and considering to what degree you have to comply with Ban the Box. Obviously, certain aspects, if if OAPSA tells you you need to do certain things, then you need to do them. If CMS tells you you need to do certain things, you need to do those things, and ban the box can't stop you from doing that. And then this is a really dynamic area of the law. We're seeing not only state activity, but obviously local activity, and so I think that this is an area that continues to develop, and so it's something that you should all be keeping towards the top of your mind as you go through and implement these policies.
Thanks, Andrea. I just want to spend a few minutes before we turn to questions, of which we've gotten many already, to talk about some other considerations. If you're doing the exclusion checks, which you should be doing to check whether someone's been excluded from participations in the federal and state health care programs, revise your job applications to include the fact that you're making exclusion inquiries, and ask specifically, the condition of employment is that someone not be excluded. Because let's say you've got someone who has both a criminal history and they're also on the OIG list of excluded individuals or entities. Well, you can't hire them if that's your policy, and certainly federal law prohibits you from paying them or taking orders from or referrals from someone who's excluded. That in and of itself could trump the fact that the person also has a criminal history, because your reason for not employing them would be that they're excluded. So consider, when you're reviewing your applications as well as your job descriptions, as Andrea said, include on the application, have you ever been or are you currently excluded? You want to ask as well all applicants to provide any names they've ever used, because unfortunately you cannot do an Office of Inspector General exclusion list based on Social Security, and we're seeing lots of people who've gotten hung up because someone has applied for a job using their maiden name, but they were excluded under a married name. You want to also specify on your job applications the fact that falsification is grounds for termination, and that would apply to any fact that's on their job application. If they've lied about it, as Andrea said, you fire them because they're a liar, not because they've done whatever the offense is that they lied about. I'd also suggest that you advise them that you're running exclusion checks, and include as well the fact that non-exclusion is a condition of employment. And I say that because if you have someone who you've employed and they're excluded and now you need to get rid of them, you don't want to get stuck with an unemployment compensation claim, right? You need to really take this opportunity, as we said at the beginning, and really start evaluating how you're doing your employment practices. I'd include as well these issues in your advertisements, as well as an ongoing obligation to notify you if you've been excluded, and likewise, if you've been arrested. It's something that you may want to have as part of the ongoing job responsibilities. Finally, to the extent that you have a union shop, you need to be considering the implications of all of this on your collective bargaining agreements as well. And at this point, we're going to start with questions, and we're, I think, start in the order that we've received them. If we don't get through all of your questions, and they've been sent in during this time, we'll provide an FAQ that'll be posted on the PHA website for questions that are submitted during the webinar.
Yeah, the only thing that I would say is I did see a question. Someone was asking if ban the box applied throughout the Commonwealth, and no, it doesn't. Ban the box is a Philadelphia ordinance. It only applies to Philadelphia County. So if you have a facility in Philadelphia County, you have to comply with ban the box. Again, there's an exclusion for if you, you know, are required to do certain things under federal or state law, so that you have to look at the interplay. But no, if you're outside of Philadelphia County, that's one thing you don't have to worry about.
Okay, the first question is, how would you view a recent, say within 3 years, misdemeanor conviction for disorderly conduct, given the challenges of working with patients who many have behavioral issues, fast pace, and just the daily challenges of working in a nursing home?
Yeah. So, you know, certainly if someone has a disorderly conduct conviction and if they're providing direct resident care, that's something to seriously consider. It may make sense to assess what the nature of that situation was. Again, you know, going back to one of the cases I referenced, you know, if you just hear that someone was convicted of murder or manslaughter, you think, oh my gosh, the person killed someone. I can't have them in my workplace. But when you hear that it happened 30 years ago and that it was, you know, when someone was threatening his family, you think to yourself, oh, okay, well, that's a different situation. So if the person, you can paint a picture of a person who was in an abusive home and got into an altercation with their spouse who was abusing them and injured them, and then they were convicted. That most likely it wouldn't happen, but just, you know, trying to create a hypothetical, then they're convicted of disorderly conduct. So I think certainly that type of conviction, if someone is providing direct resident care, absolutely merits further inquiry and analysis to determine what the nature of the circumstances were. And if you determine there was a nexus, so it was in the workplace or it spoke to their larger situation. It's also, the conviction is one piece of data among everything else. And so the question is, what's the rest of the picture? Is this an isolated incident? What is the rest of the employment history? What do the references say? So I think the challenge here is that you all are used to having bright lines and defined lists. And so this decision and the current state of affairs requires more time in assessing these issues. So I don't think there's a yes or no answer here, but those are some of the things to think about as you're assessing whether to hire the person.
And certainly, you know, as Andrea mentioned earlier, a job description that includes some reference to ability to work under stressful conditions would be supportive potentially in a situation like this.
And if you have certain folks who work with certain types of residents, I mean, I'm sure that people are traveling around the facility, but you know, you could have additional requirements. It may make sense to consider subcategories of jobs and different job descriptions based on the nature of the population that that you have the employee dealing with to further bolster.
Okay, the next question is, we are a commercial construction company that works within senior living and senior care facilities. Are we required to adhere to Peake for our staff and subcontractors? And the quick answer to that is no. The second answer is probably. And I say that because the construction company is not a covered entity under the Older Adult Protective Services Act. However, the senior care facilities that the construction company may work with may impose requirements on the contractors to make sure that construction workers who are in the building who have potentially direct access to resident rooms not have criminal convictions. So, the question raises two good questions. One is, even if your contractors are not covered by the Older Adult Protective Services Act, there is nothing that prohibits the facilities, and in fact, OAPSA would require you to make sure that to the extent the contractors fall within that definition of employees, and I refer you back to slide number 25, contract employees who have direct contact with residents or unsupervised access to their personal living quarters. If you use that, if you're the senior facility, you may want to consider that.
And I think that, to the extent that you all subcontract out any functions, whether it be a cafeteria or whether it be cleaning services, look at, what are your contractors doing, and do those subcontracting employees have access, as Paul is describing, because there are obligations there.
The next question reads, oftentimes we receive letters from community legal services when we turn down a potential employee for hire because of a criminal background. Sometimes the offense may not be on the list from the Department of Aging, but something like theft, which goes toward a character thing. So a couple points on this one. To the extent that you are a skilled nursing facility, you can go back to that material we started the webinar with that talks about theft from the survey guidelines as a condition you could consider, outside of OAPSA, as a reason for not hiring somebody. That's point one, and that's why I went through at the beginning giving you that additional detail. But point number two, let me just take a minute to talk about organizations like Community Legal Services. They and several other public interest law groups have been very interested in challenging laws that place burdens on people with criminal histories. Those types of organizations are the ones who helped bring the Peake case. They certainly worked on the Nixon case. And I think they're going to continue to look for attractive plaintiffs to try and chip away at laws like OAPSA, like the Child Protective Services law that also has these kinds of bans and prohibited offenses. So it does not surprise me, and I think we will continue to see letters of inquiry from organizations like this or plaintiffs' firms, because some of these other laws that Andrea went through provide for attorney's fees if the plaintiffs are successful. So, I think if you're going through and exercising your reasonable diligence and documenting, the fact that you make a decision not to hire someone because of a theft conviction may be a reasonable one, may also be one that someone can challenge, because just the fact that you've done it doesn't mean somebody can't sue you.
Absolutely, right. And the statutes, the Criminal History Record Information Act, someone can go straight to court. There's no obligation to exhaust administrative remedies, whereas under Title VII and the Pennsylvania Human Relations Act, you would see a charge of discrimination and you would be in an administrative agency.
The next question. We have a current CNA who was reported by his 16-year-old daughter to the Department of Human Services for abuse. The CNA has informed us it was because she hit the daughter. The CNA was arrested and released pre-trial with reunification efforts in place. Trial is not for 6 months. We want to retain the CNA, no conviction, good CNA, has handled this situation honestly and with responsibility. What do you recommend?
Yeah. So again, I think that, you all know how long this person has worked for you, what the employment history is. It's a little different when you have a current employee than when you have a prospective employee, because you have a current reservoir of knowledge and a basis to conclude one way or the other, at least, as much as you can based on all the information you have, whether this is out of character, whether this is indicative of a larger situation. But, what the EEOC would say, obviously just the fact of the arrest can't be a basis for taking an adverse action. You all appropriately are then doing many of the things that the EEOC says you should do, which is to look into the underlying conduct and assess if the conduct questions the ability of the person to do their job. And it seems like there's a preliminary decision made here that the person's a good employee. Maybe this is out of character for them. But I think those are some of the things to think about when you're analyzing the situation and determining how to handle the situation. But if this causes you to think that the person is going to risk the safety of residents, then you would want to document that, but it seems that that's not the preliminary assessment made. Oftentimes in these situations, there are factors and multi-part tests and things like that, but you know your people, and so often it's, at the end of the day, for this type of situation, going with what your gut tells you initially, and then you can always reassess as the situation goes on if you decide to retain the person, as you get additional information and as the situation develops.
The next two relate to FCRA, and the questions are, if you're getting the background checks directly through the patch system, so you're not using a third-party vendor, does FCRA apply? And the answer would be no. Right. If you're because you're going straight through the state contracted agency to do that, unless the Department of Aging comes out with a subsequent ruling that would say that they consider the patch system to be a separate third party. But absent that, for what we know right now, FCRA would not reply. Next question had to do with what these revisions, what impact will that have on individuals who show up on the exclusion check. I would use the exclusion check preemptively, and we've discussed that one. Can you help with suggested language for a prospective employee declaration from asking if they have had previous convictions on the prohibited offense list? I'm not sure what that one is exactly, what that question is exactly asking for. Andrea, do you?
Well, so it seems like this may be asking for language on a job application, so inquiring as to whether they have previous convictions that would be on that prohibited list, the OAPSA prohibited list. I think you know, certainly if you're a Philadelphia-based employer, you have banned the box, so you're not going to be asking that on the job application. That's not to say you're not going to be getting the background check. As Paula said, everyone should still be getting the background check as required by OAPSA. And then once you get the background check, it will list what convictions the person has. You certainly, as Paula said, could put a question with regard to whether there are any exclusions or you're on the exclusion list, but I don't know about prohibitive offense. I assume that's a reference to OAPSA, and I think you're going to get that information. It may make sense to consider a broader question. Is there anything that would prohibit us from employing you, or something more broad and not as targeted?
But you could ask, have you ever been convicted of, if you're not in Philadelphia,
Sure.
Have you ever been convicted of a crime? And if they say no and you get a positive hit, you can fire them for falsification of information on the application if you've advised them on your application.
Right.
You expect all answers to be truthful. The next question is, if you decide not to hire based on what you said, how are we protected against an applicant saying we are using their past against them? And to the person who asked that question and the many others of you who are feeling that pain, I would take the second slide. You're between a rock and a hard place. And unfortunately, in these situations, you're really looking at a choice between two evils. Do you take the risk of hiring somebody you think is going to hurt your residents, or do you hire them because you're afraid of the risk that you're going to get sued? And that is a rock and a hard place, and depending on the facts, you may choose the employment suit over, Department of Health or Department of Human Services violations and a potential malpractice case for negligent hiring.
Right. I do think that, if that's the preliminary conclusion that you're reaching with a situation, that you think that a conviction really precludes them from working in a specific job, take a step back, think about it, and think, what if this is subject to challenge later on, what is it that I say? How do I articulate the nexus between the job and the criminal conviction in a way that would better protect me? And maybe that helps you make the decision. Ultimately, it doesn't make the decision for you, but if you can strongly articulate that reason, then that puts you in a much stronger position if you decide to take the employment risk and not the regulatory risk, and not hire or take the adverse action against the person.
If someone does not have a criminal record but you decide to not hire, do you still need to notify them in writing?
So the provisions that we were speaking about, the Criminal History Record Information Act and FCRA and Philadelphia, it relates to criminal background. So you decide not to hire someone for another reason, need to provide them with specific notification as to why, and you don't need to do it in writing.
Our application asks, have you ever been convicted of a felony? Yes, no. If yes, explain. Is this allowed now? Unless you're in Philadelphia, there's no problem with a question like that. We do the following checks in addition to the PA background check: meta check, National Sex Offenders Search, SAM, OIG. Does the applicant need to be notified that we are doing these, and legally can we do them? You absolutely can do them. There's no prohibition against doing them, and it certainly is good business. The question is, if you're using a third party to get some of this information, you may be subject to FCRA. Do we need to do criminal background checks on volunteers? OAPSA does not require that you do that. Some organizations choose to do that anyway. That's up to your organization. What types of evidence of individual rehabilitation could employers request or look for?
So there aren't specific requirements as to what types of evidence, but I would start with what their employment history is otherwise, how long have they been employed since the conviction, a lot of the things that you would do in your traditional process anyway, what are the references saying, that sort of thing. So assessing the applicant and determining what's happened since the conviction has occurred.
Based on this information, as a home care agency under OAPSA, can we do criminal checks prior to the offer?
So the ban the box ordinance speaks about conditional offers of employment and that you can't do a criminal check prior to a conditional offer, but to the extent that you're required to comply with CMS and OAPSA obligations and you need to get that background check, that would trump it. So you don't have to wait until you make that conditional offer.
Do we know if the Peake plaintiffs were arrested after their prohibited arrest or convictions, looking at the question of patterns of behavior, and that the facts as they're laid out show that some of these people did have multiple arrests, but there's been a substantial passage of time between their convictions and their denial for employment.
But I do think that the question points to a broader question, which is, do you have to look at each conviction in isolation and do that assessment? And I think that it's reasonable if there are multiple convictions, and obviously you have to look what the basis is for each conviction, but if there are multiple convictions, is there a pattern? Does that question the judgment of the individual? Again, a lot of the factors that we've been looking at, how long ago were those convictions, what were the convictions at a young age, and as we saw with the folks who were borrowing cars from their friends and relatives, they might not even have known that they were in a stolen car and gotten some legal advice that they should plead guilty, and they didn't want to miss work to go to court because they thought they were going to lose their job. So I think, as with anything, it's really looking at the whole situation and determining whether as a whole you think any of those convictions, either individually or collectively, question the suitability for employment given the job duties.
Disorderly conduct is almost always a summary offense. The prohibited offenses at a minimum require 2 misdemeanors. So wouldn't we be violating the Peake decision if we didn't hire that person? You can look at a number of factors when you hire somebody, right? So you may not like the way they answer your questions. Then there are all sorts of reasons that you may determine not to hire someone that is separate from the fact that they may have had a conviction for disorderly conduct.
Right. And I think, the OAPSA list is provides you with guidance, but just because someone's conviction isn't listed, or they need 2 and they only have 1, again, you're looking at the whole situation and determining whether that piece of information in the larger context merits a determination not to hire.
Okay, earlier in the presentation, you referenced several times the finding of guilt for abuse. What I meant was that's a substantiated finding of abuse in relationship to a nurse aide. There may be other types of abuse type actions that someone may have been convicted of relating to residents specifically. Do you mean, is it reasonable to include a specific question on the questionnaire sent to previous employers whether the applicant has been the subject of a substantiated finding of abuse while employed with them? The substantiated finding of abuse that's in the CMS guidance and regulations refers specifically to a finding by the state agency. Many, 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 many times, those of you who are on the phone have substantiated finding of abuse through a PB-22 or an abuse and neglect investigation. That substantiated finding of abuse is not the same thing as a finding and as an official finding by the state agencies. Separate comment, contractors must do reporting pursuant to the Elder Justice Act. The Elder Justice Act reporting refers to making reports of the witnessing of suspected criminal activity involving nursing home residents. It does not apply to getting criminal background checks. Currently, our applicants are not providing proof that they have applied for a background check. We make offers conditional on the outcome of the background check we conduct. Should we start requiring applicants to provide proof that they have applied for a background check even if we are conducting our own? And there's several questions along this line. The findings from the FBI reports are going directly to the applicants. I don't see a problem with telling the applicants they have to give you proof of their background check before you employ them. Certainly the Department of Health, Department of Human Services, and Department of Aging are going to look for evidence of those background checks.
And so one question, it says, in reference to your, quote, cook example, my concern is the possibility, say 5 years down the road, the cook transfers to one of our home health positions. We currently don't run new background checks on internal transfers. The DUI may not be a factor for a cook, but it is a factor for our home health aides. So that's a great question, and I think that since the analysis is two-part, it's a nexus between the conviction and the job, and then if you are changing one aspect of that calculus by transferring them to a very different role, it probably merits looking at doing a refresh on the background check or looking back at the background check that previously was done to assess the suitability of employment for the home health position. So in that example, you would already have the DUI in the background check, so you could just look back at the file and assess whether it would be appropriate to transfer the person.
Okay, we've got several questions that we have not addressed, but we are out of time. So for the ones that we have received, if you've sent them into PHCA, we will respond, and PHCA will be posting an FAQ on their website. But at this point, we signed on for a 2-hour webinar, and it's now 12 o'clock. I want to thank everybody for their participation, and we'll now turn this back over to PHCA.
Thanks, Paula and Andrea. It was great interaction on this webinar and everyone who attended. This presentation will be made available on PHCA's website later today, and credit certificates will be emailed to attendees following. Thank you all for attending. This concludes our broadcast.